Hello everyone, my name is Jim Mayor, a professor here in the United States specializing in immigration law. The inauguration of Donald Trump as the 47th President of the United States is scheduled to take place on Monday, January 20th, 2025. What type of immigrants are at high risk of being deported by Donald Trump policy? I'm doing this video because there is a lot of misleading information being spread online by people that are not lawyers, your cousin, your friends, on TikToks or anything that sort. This video will address three issues. The first issue is which categories of immigrants could be affected by Trump's deportation policy. The second issue is what are the existing mechanisms that can protect undocumented immigrants. And the last issue is what does Trump seem to be proposing? Okay, the first question is which categories of immigrants could be affected by Trump deportation policy? Okay, if you were here, you came with F1 visa as a student, you are not concerned. If you are here, you come with a B1 or B2 visa, you are a visitor, you are not concerned. You came here with a visitor visa and you decide to apply for an asylum, what they call affirmative asylum. You are not concerned. You came here, you crossed the border illegally, you were detained, and then you were released, you receive a notice to appear ATA. If you have to appear in front of a judge, immigration judge, you are not concerned. Those who are concerned or who are in high risk of being deported by Trump's administrations on 2025 are those who are undocumented immigrant or illegal immigrant. What are they? For instance, you came here with a visitor visa and you decide to overstay, or you decide to file an asylum, and then you pass the first interview in front of an immigration officer, your application was denied, and then you have to go to a place on the you were placed on removing proceedings. You have to appear in front of a judge, immigration judge. Your application was denied, and then you were in appeal, your application was denied. You are concerned about this because it becomes illegal, you have to leave the country. Or you crossed the border, you were detained, and then you were released, you received a notice to appear, and then you decide you never show up in front of a judge. Or you showed up, but your application was denied. You have to leave the country. Or you pass the appeal or the proceedings, and then you have to leave the country. And then you never leave the country, you decide to stay in the United States. You are illegal immigrant. You are concerned you will be high risk of being deported. Okay, the second question is, are there existing mechanisms that can protect undocumented immigrants? The current immigration's detention policy authorizes immigration officers to detain asylum seekers even after passing the credible fear interview. So the credible fear interview is a screening mechanism allowing immigration officers to select potential asylum seekers. Now, in Jennings against Rodriguez, the Supreme Court ruled that asylum seeker or unlawful entry seeking asylum are not entitled to invoke due process, meaning that asylum seeker cannot seek release. Now, however, in a previous Supreme Court ruling, especially Zadivers against Davis and Clark against Martinez, the Supreme Court ruled that unlawful entry or anybody or undocumented immigrants are entitled to invoke due process as long as they are in the United States territory. Now, I argue in this article that the Supreme Court recent ruling denying asylum seeker the right to invoke due process create legal uncertainty, and to establish that the court traditional approach is preferable. It complies with the plain language of the Bill of Rights. And what does the Bill of Rights say? The Bill of Rights protects anyone within United States territory. First one is what's called congressional approval. Congressional approval right here when we know that the President of the United States has a power, executive power to deport people. Yes, he has that power. He has also power to do some reform, like Trump is about to do a reform on diversity visa program. But I think he mentioned that himself, that he has to contact the Congress first to decide, because he can't do it without congressional approval. This is the first mechanism. So he needs congressional approval to decide. And now the question is, can the President of the United States stop an existing law? No, he cannot stop an existing law, but he can use presidential or executive order to clarify or to further an existing law. Now, the second mechanism which is important is judicial review. Judicial review is when federal judge have power to declare any laws or executive order unconstitutional when this order or laws does not comply with the Constitution of the United States. And the simple example is when Trump, in his first term, he signed what they call Muslim travel ban. And Muslim travel ban was stopped by federal judges because they declared this unconstitutional. Thank you for watching this video. I hope this video was helpful. If you know somebody in the same situations, please share the video. And if you have a question or comment, please look it down there. We have our contact number or our email address. Please shoot us an email or any question. And above all, please do not panic. Find yourself a lawyer. Take care.